Hi, I'm Wayne Zell. I'm an estate planning and business planning attorney in Virginia, Maryland, and the District of Columbia, with over 25 years of experience in counseling thousands of clients. I'm talking about the basics of estate planning, and right now I want to discuss what you should have. It's important to have a will and a revocable trust to achieve your estate planning goals. But that's not the whole picture. You also need a healthcare power of attorney, an advance medical directive, and you also may want a living will to take care of your healthcare needs if you ever become incapacitated. If something happens to you, you're injured, you're in an accident, or you become unconscious for whatever reason, you've got to ask the following questions. Who will make decisions for you in regards to your health care? Who's going to receive information about you? Who's going to have access to your personal health information so it can be communicated to people who need to know? A medical power of attorney or healthcare directive allows you to address some very difficult questions. Let's say you've got Alzheimer's disease or another type of dementia, which has now progressed to the point where you do not recognize your loved ones, and spoon feeding is no longer possible. Do you want to be fed by tube? Another example. Let's say you're seriously ill, and chemotherapy is going to have severe side effects. Do you want to endure the side effects if your chance of regaining your current health is less than 1%? These and other difficult questions can be addressed in your medical directive. It allows you to express values regarding your physical and mental well-being. The ability to see and taste and touch and read if you're aware of your surroundings. And if you want to be independent, you can express this all in your medical directive. The medical directive also allows you to set priorities over current and future healthcare needs. You can establish your preferences regarding long-term care. If you want to be in assisted living or in a nursing home, or would you prefer to be cared for in a home-based setting? The medical directive allows you to establish goals regarding your end-of-life care. Apart from the medical directive is the living will. It can be included as part of the same document, but many states require it as a separate document, so we usually draft it as a separate document. Now, a living will is not the same as a will. It's an expression of what you want to have happen. If you're terminally ill or you're in a persistent vegetative state and death is imminent as determined by your physicians, do you want to have life-prolonging procedures withheld from you? These procedures include respiration, nutrition, hydration, antibiotics, kidney dialysis. Your living will also may designate whether or not you want to have organ transplantation and other life-prolonging procedures. Do you want the decision on end-of-life care to be left up to your physicians, or do you want it to be left up to your loved ones? Loved ones may not be able to let go, or in some cases may want to pull the plug too soon. A doctor also may not or may be the best choice for you because not all doctors are created equal. The timing in the living will is also critical. You can state that the termination of life-prolonging procedures is only to be executed after a specified waiting period. Having a living will or not having a living will is important in considering its effect on your loved ones and your estate planning goals. For example, by not having a living will, you could deplete your estate assets by remaining on life support, remaining in the hospital, and if insurance runs out, the assets in your estate could be depleted. So having a living will is always a good idea. You can also include your religious views in these documents. For example, if you're Catholic, you may want to withhold life-prolonging procedures other than artificial nutrition and hydration. This is based on dictates from the Roman Catholic Church. If you're Jewish, you may want to have your rabbi decide who and when is going to make the decision over when to terminate your life. Think of Terri Schiavo and what her family went through in the 1990s and the early 2000s because she did not have a living will. Next, we're going to discuss other items that you may want to have to assist in caring for you in the event of your incapacity.